Hello, my name is Aziz Saliba. I'm a professor of international law at the Federal University of Minas Gerais and the current president of the Brazilian branch of the International Law Association. The International Law Association was founded in 1873 and has as its mission the study, clarification, and development of international law and the furtherance of international understanding and respect for international law. If you're interested in international law, I invite you to subscribe to our channel, follow us in social media, and consider joining the Brazilian branch of the ILA. Our discussion today will focus on the regulation of international mobility. According to the International Organization for Migration, there were 272 million international migrants in 2019. That corresponds to 3.5% of the world population, and if it were a country, it would be the fifth most populous country in the world, below Indonesia by 1 million people and above Pakistan. International remittances amounted $689 billion in 2018. That's a figure larger than the budget of Spain, Russia, or Australia. But there are other interesting figures related to global mobility. Since the Second World War and until the pandemic, tourism had been increasing exponentially. In 1950, there were 25 million tourists, whereas in 2018, there was a record of 1.4 billion international tourist arrivals, according to the World Tourism Organization. Even if we consider that the number of arrivals is higher than the number of tourists, as many people will clock up more than one trip, the figures are staggering. In Brazil, we have never had as many nationals living abroad as now. The number of Brazilians living abroad has increased 35% from 2010 to 2020. The official estimate is that about 4.2 million Brazilians are living in other countries, but some researchers argue that the actual figure might be double as much. However, despite the impressive numbers related to international mobility, the current legal regime regulating global mobility is fragmented in some respects, outdated in many others, and quite often lacks coherence and fairness. So, the Columbia University's Global Policy Initiative put together a commission of 43 specialists who, after 2 years, presented, and I quote, a framework for mobility with the goals of reaffirming the existing rights afforded to mobile people and the corresponding rights and responsibility of states, as well as expanding those basic rights where warranted. End of quote. The proposed convention is comprehensive in scope and length, as it addresses in 213 articles the minimum rights afforded to all people who cross state borders as visitors and the special rights afforded to tourists, students, migrant workers, investors and residents, forced migrants, refugees, migrant victims of trafficking, and migrants caught in countries in crisis. To discuss this convention, we are privileged to have with us today Professor Michael Doyle. It is probably unnecessary to present our guest to those of us who study international law, international politics, or international relations. It is certainly impossible to describe in a few words his notable career and accomplishments. I'll try my best. Professor Michael Doyle obtained his PhD in Harvard in 1977. He has previously taught at the University of Warwick in the UK, at Johns Hopkins University, Princeton University, and Yale University. Professor Doyle is one of those few who have talked the talk and walked the walk. In addition to his outstanding academic contribution, Professor Doyle served as Assistant Secretary General and Special Advisor to United Nations Secretary General Kofi Annan. He is the only person that I know who has received two important prizes from the American Political Science Association. The Marion Award, which is given to a person whose published work and career represent a significant contribution to the art of government through the application of social science research, and the Herbert Humphrey Award, which is given in recognition of notable public service by a political scientist. Professor Doyle is a member of the American Academy of Arts and Sciences, American Philosophical Society, of the American Academy of Political and Social Science, and of the Council of Foreign Relations. He also chaired the board of the International Peace Institute from 2016 to 2018. His list of publications is quite extensive and relevant, so I'll have to pick here. His 1986 essay, Liberalism and World Politics, is the 16th most cited article in the first century of the American Political Science Review. And another recommendation that I personally enjoy very much is Striking First, which was published by Princeton University Press and deals with doctrines of preemption and prevention. Professor Doyle's text is followed by a series of commentaries by distinguished academics. Professor Doyle's presentation will be followed by reactions and questions from our three discussants here, Luciana Valadares, Ana Luisa Zago, and Flávia de Ávila. I will present each one of them before their turn. Professor Doyle, thank you very much for accepting our invitation. The floor is all yours.
Professor Saliba, thank you very much for that exceptionally kind and generous introduction. I'm delighted to be with friends in Brazil, Minas Gerais in particular, and also, of course, to reconnect with a wonderful former student of mine, Luciana Fernandes. It's a real pleasure for me to be here. I'd like to take a few minutes, as you just mentioned, to describe briefly the Model International Mobility Convention. I want to highlight two special features of it. I want to connect it to the real world, which motivates its creation, and then talk about how it fills two gaps in international law of mobility that Professor Saliba just referred to, that is with regard to refugees and temporary migrants, and then have a brief concluding comment on the nature of this convention as what we've called a reasonable, realistic utopia. That is a vision of the future that is normative, that does not yet exist, but one that reasonable, frankly, better governments than we currently have could support as being to the advantage of all of their people. So that's my plan. Let me talk first about some special features of a mobility convention. The two features I'd like to draw to your attention, and Professor Saliba just mentioned them, is that it is comprehensive and it's cumulative. It's comprehensive in that it covers everything from short-term visitors and tourists and foreign students through migrant workers, residents, investors, refugees, and forced migrants. And this is unusual. And it's cumulative. It's based upon the idea that a visitor needs to be able to exercise some of his or her rights. If I were visiting, for example, Minas Gerais, I'd want to have my basic freedoms of speech and thought. If I walked across the street and got hit by a bus, I would want to have emergency medical care. If I rented a car and hit somebody else, I'd want to have fair access to the courts. But that's just about all that I can claim. I don't know Brazilian law well, but I really doubt that I could get a job, perhaps buy property. I certainly wouldn't be able to vote in your election. And so as you change status, you need more rights. If you're a tourist, you need to have your contracts honored. If you're a student, you need fair access to the university and a transcript when you are done. If you're a migrant worker, you need access to equal pay for equal work, to unions, etc. And if you're a refugee or a forced migrant, you need to have all of the rights that have been denied to you in your home country given to you in your country of refuge. So the convention is both comprehensive, it covers mobility soup to nuts, visitors to refugees, and it's cumulative. It's based upon the idea that you get access to your basic rights in increasing amounts as you need them. That's the model. It responds to the real world of people on the move. In 2020, there were 281 million international migrants, that is, people living outside their country of first jurisdiction for a year. But as Professor Saliba mentioned, there were many, many more, over 1.4 billion visits per year. And this is migration has a regulatory regime, visitors do not. There were 79 million people who were forcibly displaced. 53 million of them were internally displaced, so not necessarily direct concerns of international law. 26 million, however, had been forced to cross a border. They were part of refugee law. But the problem is that most of the world's refugees are being cared for not in Western Europe or the United States. They're being cared for in the developing countries. 85% of the world's refugees are being cared for in developing countries, the least in countries in terms of those that can afford to pay those costs. While the rich countries, Western Europe, United States, and Japan, do not provide adequate financing, do not share responsibility in a way that it needs to be. So that's the real world of migration and refugees. The legal architecture here is limited. The two major conventions, the 1951 Convention on Refugees with the 1967 Protocol, and then the 1990 Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families. What's missing are regimes for visitors, tourists, foreign students, etc. There are other regimes on which we can draw, human rights regimes, but we're missing some important frameworks for the movement of people across borders in all of those variety of different ways. So a number of colleagues and I got together, this is dating way back to 2015, when Luciana, as a matter of fact, joined a workshop to help develop innovative ideas. And then we assembled 43 experts from around the world to design this treaty, to fill gaps in the existing architecture. One gap has to do with refugees. The current regime for refugees in the 1951 Convention requires that in order to get refugee status, that a person has been persecuted, that is with intent, because of race, religion, nationality, social group, or political opinion. They have a right to non-refoulement. They can't be kicked out, but they have no direct right to arrive and make a claim under this basic law. And the rights they have once they get refugee status are equivalent to other aliens, not citizens. Many countries, thank goodness, are more generous than that basic law, but not all are. And so Mimc addresses those problems. It has a broader ground for asylum. A forced migrant who has the rights equivalent to a refugee is someone who is fleeing any external threat to life or arbitrary incarceration. When you flee to save yourself or your family from some external threat, you can potentially qualify as an asylum seeker and get refugee equivalent status. We, in this convention, provide rights equivalent to nationals, not just aliens, and that includes access to education and employment. And, for example, we provide a right to enter for refugees who are fleeing directly from persecution or the threat to life or serious harm. and they've been pre-certified by UNHCR. And lastly, we create a regime for sharing responsibility so that all countries bear a fair share of the cost of either directly housing refugees or providing financing when others do so. So we're filling in important gaps in refugee law, broadening it and providing better regimes for joint responsibility. With regard to migration law, for example, the 1990 Convention includes some valuable rights to unionization, equal pay, legal process, but unfortunately, it has no ratification by countries of net immigration. And that's a problem. It means it's not doing its work to protect migrants. And that's because many of those countries see it as including too many rights. It makes temporary migrants equivalent to nationals in education access, housing, university education, healthcare, etc. The problem with it is that it has, that is the 1990 Convention, is that it has too many rights that are too generous, fully equivalent to national citizens, and also too few rights. It doesn't include rights to multiple visa entries for temporary migrants, portable pensions earned while they're working in their host country, and protections so that they don't become permanent temporary migrants. And we address all of those things in the convention. And that's, I think, a major step forward. And we include rights and regulations with regard, as I mentioned, to tourists, foreign students, investors, residents, and others. So it really is an ambitious document. So why do we think this would be a document that a reasonable country, I don't say an existing country, I can tell you about my experience in advocating for this convention with existing countries, if you'd like me to do so, but a reasonable country should be willing to sign it. Compliance will be difficult. We are expanding rights, and we know that. This is strengthening human rights for all those who are crossing borders, and we include undocumented labor migrants, forced migrants, refugees, and those trafficked. The biggest winners, of course, who would be happy to comply with this new convention are the vulnerable and the mobile. But of course, they themselves can't enforce a new convention. So we built in reciprocal benefits into the convention as a reason for states to someday be willing to sign it, including responsibility sharing for the countries like Turkey, Lebanon, Jordan, Pakistan, Kenya, and others who are hosting, Colombia, who are hosting so many refugees in the world today. They'll like this convention. For the countries like the US and the EU, they will gain laborers and investors, but most importantly, they'll gain a more regularized and orderly regime for the movement of people. And this should be attractive to them. They already greatly benefit, as do countries like Brazil, from international travel and tourism, an industry that in 2014 amounted to $4 trillion of global GDP and 160 million jobs, and also international education. Foreign students in the US alone spent $32 billion in 2015. If we had a world regime for mobility that was better organized and more regularized, and once the COVID epidemic is hopefully contained, that will produce benefits for all countries. And that, I hope, is one other source of motivation someday for states to sign this convention. But lastly, we know that self-interest will probably not be sufficient. We'll need to appeal to the better angels that lurk, we hope, in the hearts and minds of citizens across the globe, so that they will be willing to stretch out their hands in solidarity to those who need help, under the view that, someday, under other circumstances, we too might need help. And we would appreciate the ability to move across borders in a regular and safe way, and if needed, because our lives were at risk, get asylum in another country if we can't find peace and security in our own. So that's the convention. The next steps that we had in mind is we're approaching international NGOs, municipal and regional governments, the private sector. We're trying to develop a network of support. It's currently housed at the Carnegie Council in New York, and we're promoting the treaty. Our aim here is to display the value of what a better regime for mobility would look like, to take away undue fears, and hopefully to assure people that this kind of regime would be useful, honorable, would reflect the dignity that we want all human beings to be treated with. And so we are put together this convention, and we are advocating for it in the various different places where we can do so. Our moonshot, that is our hope, is that someday statesmen in some countries will draw upon this as raw material. They won't just simply ratify this, needless to say, but they will draw upon it as raw material and sit down and write a convention that will offer these better protections to people on the move. And something like that happened a number of years ago when international NGOs developed a landmines convention. And then at the time, the government of Canada organized a meeting in Ottawa that put together a draft convention. They persuaded 20 plus countries to join it, and it was the origin of the Landmines Convention, which has made a significant step forward in the better protection of vulnerable people from landmines. So we want to do sort of a Landmines Convention for international mobility. So let me conclude now, thanking you for your patience, by urging you to sign the convention. It can be found at www.internationalmobilityconvention.org. Please go to it, read it. If you find it useful and valuable, please add your name to the signatories. Every signature helps us establish the credibility and the legitimacy of this kind of an effort. So please join the campaign by signing the convention. And so let me stop here, and I really do look forward to the comments of my distinguished colleagues here on this panel. Thank you very much.
Thank you, Professor Doyle, for the excellent presentation of this very relevant initiative. I do have some comments, but in order not to monopolize the conversation, the two things that I will say, first of all, is that I have become a signatory of the convention, and that I would like to congratulate you for this.
Thank you very much.
And I encourage those of you who are watching at home to take a look at it, and if you believe that it's a great work as I do, to also subscribe. And next, I would like to invite Luciana Valadares. Let me just briefly present her. She works for the Office of the Federal Public Defender. She graduated from UFMG, has an LLM from the Catholic University of Minas Gerais, and another one from Columbia University. She is a member of International Law Association and a PhD candidate in international law at the Federal University of Minas Gerais. So, Luciana, your comments and questions for Professor Michael Doyle.
So thank you very much, Professor Saliba. And thank you very much, Professor Doyle, for your insightful speech. It's really a pleasure to meet you again after 6 years. Professor Doyle was the best professor I had at Columbia University, and I had the opportunity to pursue the course Modern International Mobility workshop with him. Thus, while he and other migration experts were working on the MIMC, we were discussing the issues at the seminar. I was delighted to read and sign the convention. It is a cutting-edge proposal of convention that addresses not only human mobility as a whole, but also fills essential gaps in international law. I had high expectations over it and still was surprised by the Herculean work you and other experts on migration did to turn this world better for those who cross borders. At my professional activity as a federal public defender, I have the opportunity to have close contact with the struggles of many migrants. For instance, a while ago, Zago and I spent 1 week inside the prison of Itaí, where there are only foreigners imprisoned, to provide juridical assistance free of charge for them. There are a few questions and remarks on the MIMC I would like to share with you, since our scope is not only to enjoy your speech, but also to contribute. So just to provide you with a little bit of context, Zago and I are working on a paper that provides a Brazilian and inter-American system of human rights perspective on the MIMC. So I'll provide some general remarks from our working paper, and Ana will dig into some more substantial issues, especially as regards to criminalization of migration. Brazil and the inter-American system of human rights have relevant treaties, laws, customs, and decisions on migration. So first, aiming at assessing if this perspective was considered so far by the MIMC, we analyzed the Commission members' background, namely their current affiliation and education, and all the footnotes presented in the MIMC as it was published by the Columbia Journal of Transactional Law. So the data source we used was information available on the internet, so we apologize in advance if there are any inaccuracies. I will briefly share my screen with you with a few graphics. Just 1 second, let me see if I can do that. Can you see it? Can you see it?
No.
Is it sharing? No. Just 1 second. Aqui, compartilhar. Okay. So we took a look at the commission members' affiliation, and there was only one commission member who is currently affiliated with a state member of the Inter-American Human Rights System, who is also affiliated with an institution in Switzerland. Next, we took a look at the first degree or first law degree of the commission members, and there was only one commission member who did 1 year of her first degree in Argentina, who is Saskia Sassi. And none of the commission members did their master's nor a PhD degree in country members of the Inter-American Human Rights System. So next, we took a look at all citations, and if in the footnote there was more than one citation, we counted it twice. And most of the citations throughout the MIMC are UN documents. There are also a lot of scholarship citations from the European Union and US and Canada. So then we took a look at, and regarding the Inter-American Human Rights System related citations, we only found 3, 2 of them related to family unification. Next, we took a look at the scholarship citations, and they were all in English, and none of them related to country members of the Inter-American Human Rights System. So in conclusion, the drafters, they were eminent scholars and practitioners, but none of them had effective bonds with the Inter-American system of human rights. And while researching within the framework defined, currently affiliation and education, we occasionally come across 2 bonds with Latin America that finds outside the predefined elements, which are Professor José Antonio Ocampo, who was born in Colombia, and Bianca Z. Santos, who did an internship in the NGO Conectas in Brazil. So we envision that the MIMC, as it currently stands, is a fantastic instrument, and we really look forward that it becomes an international treaty. And we have also signed it. However, we envision that the MIMC reflects a global north perspective. And as Professor Doyle mentioned, that most of the migrants are being cared for in developing countries. And significantly enough, the inter-American human rights systems has critical jurisprudence on migration issues, such as the non-criminalization of migration. So in my view, this inter-American human rights framework can contribute to the debate and steps forward of the MIMC. Finally, I would like again to congratulate you, Professor Doyle, on the cutting edge and comprehensive work on international mobility, and highlight my great admiration for the MIMC. For sure, the MIMC that aims at being a minimum standard and is complementary with other legal regimes will enhance protection for those who cross borders and are often in a situation of extreme vulnerability. I'm sure it will contribute to build a better scenario for those who cross borders. And it's impressive how you and the other drafters strove the challenge to balance the needs of different sorts of migrants and the interests of states. This recalls me of an unforgettable expression you told in our first day of the seminar at Columbia. It is, in fact, a realistic utopia. So here are the two questions I pose to you. First, I'd like to know, how do you envision the next steps to turn the MIMC into a treaty? You mentioned the Landmines Convention history, but I would like to know a little bit more on that. And second, if you envision any mechanism of participatory assessments of experts of other international law backgrounds and from perspectives of other regional systems such as the Inter-American. Thank you very much.
Great. Thank you very much, Luciana. Should I reply to you? Do I have time? Or should I wait for other comments? Professor Saliba, what would you like us to do?
Well, it's your preference here that counts.
Let me, if I could take just for a very brief reply that won't do full justice to the wonderful comments that Luciana just offered, but nonetheless we'll keep them in mind because she just made the comments and therefore I can connect to them. You pointed out that the document of the Model International Mobility Convention is very heavily, let's call it North Atlantic. It's heavily American, Canadian, and European. And that's certainly the case. We attempted to reach out to having the commission participants from South Africa, from India, from East Asia, and from Latin America. We weren't fully successful, frankly. We had scholars who knew Latin American law who were involved, but we weren't able to get the kind of global representation that a convention like this needs. So as soon as we finished the draft, we took it on the road, so to speak. So we had very interesting meetings in Nairobi, in Mumbai, in Seoul, in Tokyo, in Sao Paulo, and in Stockholm, in Northern Europe, in Florence, all designed to bring in voices that had not yet participated under exactly the point that you're raising, that it's not yet global enough. The second thing we did was to establish a network at the Carnegie Council in New York, whose job, so to speak, our collective job, is to do just the kind of outreach and reformulation that you described. You have in front of you the Model Convention 1.0 that appeared in the Columbia Journal of Transnational Law. We've already done a 2.0, which is a more succinct version of the Model Convention. And there will, if we succeed, be 3.0s and 4.0s and 5.0s possibly, until someday with good luck and hard work, governments take this seriously and themselves decide that this is worth adopting ideas from in order to create a genuine interstate, interorganization kind of a new regulatory regime. So your points are extremely well taken. They are right on spot. This is part of our current campaign, and we hope to live up to what you are saying we need to do.
Thank you very much, Luciana, and thank you, Professor Doyle, for your reply. I now would like to present Dr. Ana Luisa Zago de Morais. She works for the Office of the Federal Public Defender. She's a colleague of Luciana there. She graduated from the Federal University of Santa Maria in Rio Grande do Sul and obtained her LLM and PhD at the Catholic University of Rio Grande do Sul. Her doctoral dissertation deals with criminalization of migration and received a special commendation from the Ministry of Education. So, Ana Luisa, the floor is yours.
Thank you very much, Professor Doyle, for your speech. It was a real pleasure to be here with you. Thank you, Professor Aziz Saliba and Professor Flávia de Ávila for this so important moment. Thank you, my dear colleague, Luciana. I also would like to say how much I'm happy to work with you again. When I was in New York in 2016 to present a paper in Latin American Studies Conference, Luciana was studying at Columbia University and suggested me two authors, Professor Michael Doyle and Professor Risa Kaufman. Luciana was very enthusiastic about the possibility to return to Brazil and put in practice the advocacy in human rights in its various topics. And that's exactly what all of us are doing today, joining efforts to construct the so-dreamed International Mobility Convention. To reach this realistic utopia, we claim that is necessary, in the words of Vincent Chetale, to dominate the architecture of international migration law, a movement that distorts the conventional opposition between center and margin, outside and inside, and more specifically, the opposition between refugee and migrant worker, documented and undocumented, legal and illegal. This is one of the reasons why that is a such challenging topic. And these last few minutes, we will make just small suggestions based on the inter-American human rights perspective at the Brazilian migration law, especially as regards criminalization. As previously mentioned, we are working on a paper that provides an inter-American perspective on the MIMC. First of all, we believe that it would be a great opportunity to insert the non-criminalization principle that can be divided in four sub-principles: non-discrimination in criminal proceedings and criminal enforcement, due process in expulsion, non-criminalization of cross-border movements, non-imprisonment of migrants with fundaments in their legal status. The MIMC already provides some important standards: non-discrimination, protection against arbitrary expulsion, protection against collective expulsion, protection against torture or cruel, inhuman, or degrading treatment or punishment, the right to respectful treatment during arrest, detention, and imprisonment, the right to not be imprisoned merely on the ground of failure visa or a visa obligation. So, some standards have been dealt with, but we suggest the inclusion of specific topics based on the Brazilian migration law that we worked in this law for several years. The law is from 2017, but we have worked during 5 years in this project. And on the Inter-American Commission of Human Rights recommendations and reports, especially Advisory Opinion 18, Advisory Opinion 21, the report on immigration in the United States, and the case Velez versus Panama, judged by the Inter-American Court of Human Rights. The non-criminalization is one of the principles provided in the Article 3 of Brazilian migration law. It was one topic that we worked together in this legislation. In the case Velez versus Panama, the court established that measures of deprivation of liberty in order to punish migratory flows are incompatible with the American Convention. Moreover, deprivation of liberty as a penalty or a punitive sanction in the area of immigration control is outside the scope of the question, in accordance with the jurisprudence of the court, American court, but it must be regarded arbitrary and thus contrary to the Convention and American Declaration. Similarly, the UN's Working Group on Arbitrary Detention has affirmed that criminalizing illegal entry into a country exceeds the legitimate interest of state to control and regulate illegal immigration and leads to unnecessary detention. The Special Rapporteur of the United States on the human rights of migrants has already recommended that detention of migrants on the ground of their irregular status should under no circumstance be of punitive nature. So we suggest the impossibility to use deprivation of liberty of a punitive nature in order to control migratory flows, in particular those of an irregular nature. In this slide, we also suggest, based on the Inter-American and Brazilian perspective, the prohibition of using criminal law to control irregular migration, unless another legal asset was taken, such as in the case of human trafficking. The sub-principle non-criminalization of cross-border movements is necessary because immigration law today is closed to so many attributes of criminal law that the line between them has grown indistinct. So, the merger of the two areas in both substance and procedure has created parallel systems in which immigration law and the criminal justice system are merely nominally separate. Since then, it's necessary to avoid that immigration violations are themselves defined as criminal offenses. For less, I also would like to congratulate Professor Michael Doyle for this new model that will be the more effective regulatory framework in the architecture of international migration law. Based on my high expectations over the MIMC, I have already signed the MIMC. I also would like to do two questions. First, in which international arenas MIMC is being traded, and what is the relationship with the Global Compact for Safe, Orderly, and Regular Migration negotiations? And the second question is about family reunification. The Article 12 provides that nothing in this convention shall restrict a state party the right to decide the number of visas it issues and its discretion. After the MIMC provides the right to nuclear family reunification. My question is is if a state party had the right to decide the number of visas destined to family reunification. In Brazil, for example, the case of Haitians, children that were waiting for a visa during several years, federal justice decided that the right to limit the number of visa was not applied to family reunification in that specific cases that involves humanitarian protection. So thank you very much, Professor Doyle. It's a pleasure to hear you.
Thank you very much, Professor Zago de Morais, for your comments. And I'm delighted to hear that you thought the convention was worth signing. That's a real pleasure. Thank you. And your support sends the kind of message that we are hoping for. Your comments are very helpful. You would be further helpful to me if you sent the paper that you and Luciana are working on to me and my colleagues, therefore, which we could then do two things with your permission. Well, one, of course, we would want to read it and take advantage and be in dialogue with you. And the second thing is that we'd like to post it with your permission on the website of the Model Convention, where we are placing scholarship relevant to the themes that the Model Convention is addressing. So those two things would be very much appreciated if you were willing. On your questions, yes, indeed, this convention is highly related to the Global Compact on Refugees and the Global Compact on Migration. On migration, the one adopted in Marrakech and then endorsed at the UN General Assembly. And those are positive steps forward. And we, colleagues who worked on the Model Convention work closely as well with the two Global Compact processes as informal advisors and supporters, et cetera. So there's a close link between the two. But we said to ourselves, the Global Compacts, the two Global Compacts, valuable as they were designed to be immediate practical steps forward in existing international refugee and migration law. Particular to, try to encourage more cooperation among states, et cetera. And they were done explicitly as non-binding expressions of principles and policy. And our view was that, all support for those two compacts, but once those compacts, and if those compacts were fully adopted, there was still much more that needed to be done. We needed to have, as I mentioned, a broader understanding of the circumstances under which persons have to flee countries that go beyond the 1951 Convention, the persecution of race, religion, nationality, social group, political opinion. We needed a broader understanding. And then there were other specific elements having to do with things like temporary workers, where we thought the 1990 Convention needed attention, and introducing regimes for tourists, students, et cetera, that provided more regular flows of persons across borders. So we were more ambitious than the two compacts. We applauded them, supported them, et cetera, but even if and when they are accomplished, there'll still be more to be done. And that's what we set out to do in this long run. It could take 10 or 20 years to move the agenda in this direction. We also saw the need to strengthen elements of family reunification. They're complicated by different parts of the world have different notions of what a family is. And we thought it was important to understand those diversity, but create a floor of protection so that the closer affinities of a nuclear family would be protected and be allowed to live together in ways that both reflect basic human dignity and also are good for countries. Just from I shouldn't get into the practicalities, but some of the very best migrants crossing borders are people who already have family in the country they're going to, because they've got people who can help them settle in to the country and adjust more quickly to the new world that they're in. We also have, continuing issues that we need to address. We know there are a lot of loose ends. And I think in your comment, I didn't fully follow it, but I saw you pointing out that kind of a loose end. So if you could send us again some material on that, I would share it with some of my colleagues who are expert on questions of family reunification and ask them to weigh in to see what we need to do as we look forward to continuing to revise and improve the convention. So thank you very much for your comments. And I do hope we can stay in touch in the ways I just described.
Professor Aziz, you are muted.
My apologies. My apologies. I just wanted to thank Ana Luisa for her comments and Professor Doyle for his reaction. Now, I would like to present to you our last but not least, Professor Flávia de Ávila. She's a professor at the Federal University of Sergipe, and she's a member of the board of directors of the Brazilian branch of the International Law Association. She obtained her master's degree at the Federal University of Santa Catarina and her doctoral degree at the Catholic University of Minas Gerais. I have had the privilege of working with her for a number of years, and I'm glad you joined us in this fascinating discussion. So Flávia, you have the floor.
Thank you. Can you hear me?
Yes.
Yes? Oh, nice. Thank you very much. It's such a pleasure to be here, Professor Doyle. And I want to thank Aziz, Professor Aziz Saliba, for this invitation, because it's really a great pleasure to be here and to share the floor a little bit with you. But what I want to, the other comments were really nice. I appreciate very much. And some of the comments were in the direction that something that I would ask you, or especially the participation of other scholars from other parts of the world, not only the global. I think it's something that called my attention, and it really, I don't know if you're going to have a second negotiation, or you're going to expand this for other parts of the world. You already explained that it's happening in some sort of way, but would be nice, for example, as a suggestion, to invite other scholars, now that you were doing this work, and try to attract other scholars as well. I think would be very interesting. I was very happy when I was reading the convention that I could see diversity there, especially concerning women's rights, and I think that it's very, very important. But I missed LGBTQI plus rights specifically. And I know that there's a non-discrimination clause there as well, but racism is something that sometimes is, and not sometimes, based on our colonization system, what we face through many years, through thousands of years of colonization. So racism is in some sort of way in the structure of juridical systems in some places. So I missed this a little. I understand that there is that would be a difficult topic to deal with. But anyway, I call the attention of this, that there was a way to address this topic, I think would be interesting. I'm also concerned about, well, of course, we live in a state-centric system, so we need states to be bound by this convention. We need this. It's important anyway. But I was a little bit concerned about admission. So the word admission is being used in several articles and clauses of this convention. And for me, if you compare with refugee law, or how the declaration of refugee status that is that the states would make, and the recognition is the only does not make someone refugee, because you just have to declare that someone would be a refugee. So sometimes the word admission for me gives the state gives a state more power than it should have, and turn people that seek for this kind of help, seek for refuge, and powerless in some sort of way. I know that there is a difference between reality and what is written in the convention, in the treaty, but I was concerned about this, if there is not a step back in the refugee law and the refugee system, because nowadays it's been recognized as a personal right that we have, subjective right that we have, if we have some sort of persecution of any kind, to look for help. And then when we have this status, it would only be declared, not recognized. So this is the thing that I was a little bit concerned about, and I would love to hear your thoughts about this for sure. And well, I was thinking that something that caught my attention as well, that would be the end of refugee camps if states widely adopt this convention, would be also be the end of detention centers as well. Because there are this kind of places now that are states of exceptions, that if I can describe for refugee camps and detention centers, but I think it's a good analogy to describe them as states of exceptions in a way that the law would not be applied the same way. And there are parts of this convention that I could see that, for example, rights of all visitors, Article 25, right to liberty and security of person, Article 26, same rights, that says same rights as nationals of those states who are in the same situation. In Article 27, right to equality before law. So there's some sort of provisions, but not prohibition of detention centers and refugee camps. So I'd love to understand a little bit more about this. Because personally, I'm against detention centers and refugee camps in a way that they do not provide least rights for people that are there in human dignity way, for sure. But I know that, for example, U.S. law, if I'm not right, please correct me, sometimes the Supreme Court finds ways to be very inventive with law, I would say, to not apply constitutional rights to undocumented migrants in the United States, and to say, well, these places, they're not actually territory. They're not actually U.S. American territory. So, well, they can be there forever waiting for process, that what they call process, refugee process or migration process. and actually they do not have their own rights recognized by the system. So it concerns a little bit more if it could have a way to be more to emphasize this on the convention in a way that could be more effective. And I was also concerned about calling the countries, for example, African countries, Asian countries, where we can find refugee camps to talk, to be part of the conventions, because refugee camps should not be forever, should be just a temporary measure to receive people in like detention centers when they start the policy of detention centers as well. Should be only a temporary way to receive people until admission. I would use the same word and and they start to be there forever. So this is what is my concern. And there's another thing. Could be this convention could be an introduction for climate refugees, because there's in the general provisions, Article 125, scope and definitions, letter D, paragraph 1, and serious harm. There's a way to kind of classify, but it's like it's not specific. Could be specific. Could be an article, a clause to climate refugees that I think would be a big thing for with climate changing. It's already being difficult and will be even worse in the near future. And these are my comments, of course. And I would say that I'm very impressed by this document. I'm really impressed by this document, because it's, I was not expecting to see so many areas regulated by this document. What is really, really interesting. I was waiting for one, but I understand maybe why it's not there. That would be internal displaced people. Because of course we're dealing with a state-centric system, and it's hard to interfere in sovereign states and to help. But would be a way to help internally displaced people, because there's a very interesting aid system that was thought to help countries, not only help countries, but help people to look for their rights. So maybe it would be a topic, an issue to be in this convention. But I'm very, very glad. Thank you very much for the participation in this very interesting event.
Thank you very much. Again, if I could take the liberty of responding, Professor Saliba, could I have it?
Yes, of course.
Good. Thank you very much. Again, those are extremely insightful and important comments. They are, as you can, I'm sure you well recognize, both deep and wide. So there's a huge agenda that you suddenly transferred to me and my colleagues. But I think it's an important agenda. You know, this is an odd way of responding, but you know, the convention is a dynamic document. It's already been through a 2.0. And as I mentioned, there are bound to be 3 and 4.0s. So any assistance that we could get to help filling in those gaps that you identified would be very much appreciated. You know, if your students had time, you could ask them to write a memo on what should go into the questions that you raised. And that would be very welcome in terms of its reception here. A few comments on the very interesting points you raised. You know, we did discuss, as that commission met, we met over 8 or 9 times in person in the basement of a foundation in New York, and then by video with colleagues who could connect from around the world. And we discussed whether to include internally displaced as well as the quote unquote, externally displaced, that is refugees and forced migrants. We recognized how important the internal displacement problem is from a humanitarian and rights point of view. The worst suffering takes place amongst people who do not succeed in crossing a border. And so we're well aware of that. And so from a human rights point of view, there's a whole set of work that needs to be done in order to provide whatever international protection can be provided for people who are internally displaced. But we also knew that it was a bridge too far politically in terms of what we were trying to do, and that then opened up a whole new body of law that was less well-defined than the body of law that we were working with, the 51 Convention on Refugees, the 1990 Convention on Migrant Workers, which were the touchstones of our work. So we fully acknowledged the moral importance of the point you just made, but said, this is something for another day or another group of commissioners. And we were already fully ensconced in trying to make progress on the points we were working on and didn't think we could make a real advance on the other. We also were a little disappointed by the Istanbul meeting on internal displacement that took place. It was not at all promising. So for all of that, we recognized the importance of the issue, but decided not to pursue it. It's totally open what might happen next, but we didn't do it then. On some of the other valuable points, you talk about the issue of race, which and questions about gender and sexual identity, all of which we incorporate too easily in our non-discrimination clause. And I think you make a case that given the world we're in, it could be elaborated and dealt with more systematically. And again, we welcome ideas on what should be changed or added to there. There were a lot of things we just didn't consider. One of them, in addition to the ones you mentioned, was the issue of a pandemic, such as the one we're now experiencing around the world. We drew a firm line that to be recognized as a forced migrant and get all the protections of refugee status, you needed to have an external threat to your life or of serious harm. So is a pandemic disease an external threat or an internal threat? And we never sorted that out, frankly. We didn't. This is 2015, 2016, 2017. We didn't anticipate what was going to happen in 2019. But it's a significant gap. It just shows you that from an intellectual point of view, if this treaty is going to stay alive, it needs to change. It needs to grow. It needs to develop. And so all of those points are relevant there. With regard to climate, many colleagues are now working on this. I myself am very interested in the standards developed in the Teya Tota case at the Human Rights Committee of the United Nations, where they reviewed a New Zealand decision not to give Mr. Teya Tota asylum. He fled his home islands in the Pacific, which are slowly going underwater. He claimed to be a climate refugee in New Zealand. They said no. He appealed it to the Human Rights Committee for a ruling. They looked at it in some attention. They said no. But they acknowledged that someone might become a climate refugee. And so the question then is, what are the relevant standards? And their opinion, I think, is respectable, but very limited. And I think a lot of legal work needs to be done to define what are the operational standards that would give someone asylum on the basis of climate. Very complicated. Most people who are fleeing because of droughts and floods and things such as this are fleeing for multiple causes. Violence, oppression, as well as drought and floods, etc. And that needs to be sorted out. But it's a great topic for legal development. And we know that we need to think about that and welcome advice, frankly. You mentioned other actors with regard to admission and regulation. Very, very important. One of our accomplishments is that we add not just states to the regulatory framework that oversees the convention, but also cities, NGOs, the private sector, representatives of refugees themselves, after we are able to identify them, that form part of the supervisory regime for the treaty. That's all in the 2.0 version, which is on the Carnegie Council website. And I think that was a step forward that we did in moving from 1.0 to 2.0, but more can be done in that regard. And lastly, I agree with your comments on refugee camps and detention centers. You know, refugee camps, the old image that we have, is really an image of the past. Most refugees today are being housed in communities, in towns, in rural areas with the population, rather than being housed in camps supervised by UNHCR or national refugee authorities. We need to innovate so that we can provide better support to the non-camp assistance that goes to refugees around the world. There's something called the Jordan Compact, which has been worked on with the World Bank, Jordan, the European Union, and others that are trying to improve the ability of people to move out of camp and get employment and get housing. I think that's a step in the right direction in the future. American detention centers are cruel and unnecessary. The vast, vast, vast majority of the people who are claiming asylum status, when they are released into the community to meet with relatives and friends and you know, lead lives, go back in for their hearings and stay in the process. The idea that they need to be kept in criminal-like or prison-like conditions is unjustifiable from what I understand of that problem. And that needs to be identified better in the future versions of this convention, and more importantly, in national law in our various countries that address this issue. Many of the European countries, Germany, Belgium, Netherlands, deal with this much, much better than do the countries who lock up asylum seekers. And so it easily can be improved upon, given existing experience in parts of the world. So thank you very much for those comments. You'll see that I, not so subtly, just simply turned them around and asked you to send us your good ideas to answer your questions, and we would be grateful to receive them. So thank you.
Thank you, Flávia. Thank you, Professor Doyle, once again. We now approach the end of this debate. So I think, Professor Doyle, that the comments and questions are an indication of our excitement and willingness to contribute to the Model International Mobility Convention project. Once again, I'd like to thank you, Professor Doyle, for your outstanding presentation, for your patience and kindness in addressing the reactions of our discussants. Many thanks also to our discussants, Luciana Valadares, Ana Luisa Zago, and Flávia de Ávila, and to Fernanda Carvalho for her technical support. For those of you who joined us, I thank you and encourage you to consider signing the Model International Mobility Convention. The full convention, signature page, and other relevant material are available at mobilityconvention.columbia.edu. Thank you now.
Thank you all very much for your comments and suggestions, and I look forward to all the help that you can give us, frankly. So thank you so much.